next case to come before the court is H.B. Martin Logistics, Inc. v. Hissong Group, Inc. et al. The party should come forward. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes. If you do plan to reserve time for a rebuttal, please let me know as I'm keeping track of the time. The arguments are being recorded, so please stay behind the podium, introduce yourselves, keep your voices up. You should not use the names of any children or minors or victims should that be relevant to your argument. The judges have read your briefs and we are ready to proceed when you are. And I would just ask the appellant, would you like to reserve time for rebuttal?
I would. 5 minutes, please.
Very well, then you may proceed when you are ready.
Good morning, Your Honors. May it please the Court, thank you for your time today. My name is Matt Doney. I represent the defendant appellant in this case, Hissong Group, Inc. Hissong Group, Inc. is a dealership that sells semi-trucks. The plaintiff, H.B. Martin, which I'll refer to as HBM throughout my discussion, is a commercial trucking company that purchased semi-trucks. It had purchased a number of trucks leading up to the transaction at issue in this case with Hissong, where it bought a truck in September 2016. The crux of the case is that HBM claims that when it received that truck in September 2016, it didn't operate correctly and had some issues with it. From there, HBM drove the truck for a number of years until it sued Hissong, complaining about the operability of the truck in June of 2020. The reason I zero in on those dates is because they're very important in this case. The commercial agreement between the parties here provided that HBM was to file any claim about an issue with the truck within 12 months, and of course, as mentioned, they waited nearly 4 years, and we never believed they had a valid claim. So that's the real substantive issue before the court today. There's some procedural matters to discuss as well. One thing I would encourage the court to keep in mind throughout the discussion of each point is that contracts are not statutes, and statutes are not contracts. That was a point of confusion in the trial court that led us here today. So starting with the first assignment of error about the application.
Before you get to that,
yes.
Procedurally,
Yes.
was statute of limitations pled in an answer or a response to pleading? And secondly, when there's a contract provision limiting a statute of limitations, should that have been pled?
So the first part of your question, Your Honor, no. In the answer, the affirmative defense, in addition to the denials of the allegation, was that HBM had always failed to state a claim upon which relief could be granted. Also, we maintain that no, the pleading of a specific contract term is not an affirmative defense. At least no Ohio court has explicitly said that it is. And I'll discuss that in a bit more depth later, but those are the answers to those questions.
So you're saying because it's a contractual provision akin to an affirmative defense, it did need to be pled?
Yes. So under Ohio law, the plaintiff would always have the burden to establish each element of its case, and there was no precedent that would require a contract term to be pled as the affirmative defense.
Was that an argument you made below? Because it sounds kind of new to me. That's okay.
Yeah, I believe that was just for the appeal, Your Honor, and I'll discuss in a moment as well. You know, we had sought leave to amend the answer to check all bases if required. But as to the 12-month contract provision, you know, the parties, of course, can agree to set a specific time frame in which to bring their claims. The Uniform Commercial Code provides that 12 months is reasonable. That's exactly what the contract had here. And again, you know, HBM simply didn't comply with it. They drove the truck for year after year and then sued nearly 4 years later. Now, on that point about leave, so that argument about the 12 months, that was front and center in Hissong's motion for summary judgment, first argument made. It was briefed back and forth between the parties. The trial court ruled upon it, ruled against Hissong, and so that was fully discussed. Sometime later, HBM raised that they thought, well, we also think that contract provision should have been pled as an affirmative defense, which, as mentioned, we maintain it shouldn't have. There's no precedent for that. But in any event, the battle had already been had at that point, so we did seek leave to amend to add the affirmative defenses just, again, to cover all bases. You know, as the Ninth District has said in the radio parts company case, you know, quote, in the real world, failure to plead an affirmative defense will rarely result in forfeiture. That same case, a party's initial failure to plead a defense should prevent its later assertion only if that will seriously prejudice the opposing party. At the time the amendment was sought, and again, purely form over substance, and at no time since did HBM ever articulate any prejudice it would have faced as a result of allowing the amendment. So we think also, you know, the denial of leave to amend is also a reversible error from the trial court, because again, the issue had already been, you know, briefed in a motion for summary judgment back and forth on its merits. And that's really the heart of this appeal, you know, before the court today in the first assignment of error.
I have a question too about your contract provision limiting the statute of limitations. There's a language about accrual of the action, and
Yes.
Is there a definition within the contract about what accrual means
So,
in this context? Because my understanding is the timing of the lawsuit from the last repair is within that 12 months. Is there an issue of material fact of?
there's not, Your Honor. There's not, Your Honor. Under 1302.98, accrual occurs at the time of delivery, or there is a discovery provision within that statute. But HBM always maintained in this case that the truck was defective from the day it took possession of the truck. So that was never in dispute, that it not only received delivery, but knew about this defect from the day that it received the vehicle. In fact, and I know this is in the brief, but if you even go to perhaps the 10th service invoice at that point, after it's driven the truck like 650,000 miles, they still weren't within a year, you know, from that. So no, accrual was never in dispute below. Now, as it relates to the leave to amend, again, I mean, the seminal question before the court is the prejudice to the plaintiff. There simply never was any. Obviously, Peterson v. Teodosio was cited in the brief there. You know, the court denied leave to amend. It went up to the Supreme Court. Supreme Court reversed because there was no good reason to preclude the amendment. Same in the radio parts company case, which I, you know, quoted before. In that case, Invacare made an actual statute of limitations argument in its MSJ. Now again, in our MSJ here, it wasn't about a statute, it was about a contract term. But Invacare made that argument in its MSJ, and its adversary said contemporaneously, hey, that's not your answer, we think you waived it. So, of course, Invacare...
Excuse me, repeat that, please.
Sure. So Invacare, in its motion for summary judgment, filed, or made an argument that its adversary didn't comply with the statute of limitations. Its adversary said, that's not your answer, so you waived it because you made this argument, you know, without having your answer. So Invacare moved for leave to amend its answer, and the trial court rightfully granted that leave to amend. The adversaries weren't happy with that decision. They appealed it to the Ninth District. The Ninth District upheld the trial court's decision because, again, the seminal issue is what would the prejudice have been to Invacare's adversary at that point. There, of course, was none, just like here where there is none. And unless prejudice is demonstrated, the amendment should be freely given.
And I think I heard and understood all that. You changed your summation or your argument a little bit. I was wondering when you said about the summary judgment motions, my understanding that part of your summary judgment motion was that you said it wasn't filed within 12 months. Are you saying that was not in there?
Oh, it was. That was the first argument made. So comparing Invacare to our case, basically both I and Invacare in their MSJ, you know, I argued they were untimely about a contract term, not about a statute. Now, statutes of limitation are affirmative defense. So in Invacare, you know, they had done the same thing, where they made that argument, it wasn't in their answer. And in both instances, the other side said, well, it's not your answer, you waived it. And my point is, even setting aside that contracts aren't statutes and statutes aren't contracts, this case is exactly that case. The trial court granted leave because there was no prejudice and went up to the Ninth District. The Ninth District affirmed that, yes, there's no prejudice, that was the right result. And you know, here again, no prejudice to HBM. The issue had already been fully argued back and forth and passed upon by the trial court. This entire argument about waiver wasn't until much later in the case. obviously I've discussed this a bit to this point, but assignment of error number 2, about whether the defense needed to be asserted in the first place. Again, the plaintiff has the burden to establish all the elements of its case. You know, Ohio's a notice pleading state. We denied all the allegations. We always maintained they did not state a claim upon which relief could be granted. And so we maintain that position. In response, you know, of course, HBM has not cited any Ohio case law that said, yeah, you certainly should have pled that affirmative contract provision as an affirmative defense in your answer. And so even if the court were to decide, you know, with HBM, well, yeah, I think maybe they should have pled it as an answer, that would be an entirely new landscape in Ohio. And thus all the more reason to have granted the amendment, especially for an issue that had already been argued back and forth. So that's all I have on the last affirmative, the last assignment of error on Hissong's part. Now, HBM also appealed an issue on the granting of prejudgment interest under revised code 1343.03. We cited the 9th District's case in RPM Inc., which just maintains that the granting of prejudgment interest is not mandatory in each case. We certainly think this is a case where the trial court appropriately did not award prejudgment interest. There are plenty of cases cited back and forth between the parties, but the main center point in all of them is that the purpose of that statute is to ensure that the aggrieved party is fully compensated. The truck in this case was purchased for $140,000, and the jury ultimately awarded the plaintiff $440,000. So from our perspective, there's no doubt that they were fully compensated, you know, should they have had a cognizable claim to begin with. So with that, Your Honors, I'll reserve the rest of my time for rebuttal unless there are any other questions at this point.
You are at 4 minutes and 55 seconds, so.
Great. Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Kristen Roberts, and Charles Kampinski and I represent H.B. Martin, the plaintiff, appellees, and cross-appellants. I'd like to start today by very briefly, telling you about what this case is about. Heather and Brian Martin are a young couple who drove semi-trucks for other companies and decided to start their own business. They started their own business with a used truck a couple of years before the purchase of this truck. They obtained a contract with FedEx and needed a reliable service truck to service their route. They saved up to buy a truck, which is the subject of the litigation today. It was the first new truck that they had ever purchased. The truck that was bought from Hissong was never reliable. It lost enormous amounts of coolant, causing significant downtime, and ultimately forced the Martins to purchase a backup truck in order to service the route so that they didn't lose the FedEx contract. They also lost substantial revenues as a result of the problems with the truck. All of this was presented to a jury, and the jury found unanimously in their favor. The verdict is not being disputed. Next, I'd like to address the second and third assignments of error, as they are inextricably linked. If the court finds that Hissong waived this time limitation defense, it would effectively dispose of any remaining issues. Hissong waived a time limitation defense by failing to plead it pursuant to Civil Rule 8. Even if contractual time limitation is an affirmative defense under Civil Rule 8C.
Is it though? Is it a affirmative defense? Has any court ever said that? When it's a contractual provision and when you're disputing the contract?
We have included in our brief, Your Honor, 5 Ohio Court of Appeals cases and a number of out-of-state cases that treat contractual limitations as an affirmative defense.
That must be pled, you're saying?
Yes.
Not a 9th District one, you're saying?
I don't believe there is a 9th District one, Your Honor, but I'm not entirely sure. Under Rule 8C, it encompasses a statute of limitation defense and also includes any other matter constituting an avoidance or an affirmative defense. In Charles v. Conrad, the court held that an avoidance or an affirmative defense is some legal reason why the plaintiff cannot have any recovery on an otherwise valid claim. Hissong's defense of failure to state a claim on which relief can be granted under Civil Rule 12 is not equivalent to a Rule 8 affirmative defense, such as statute of limitations. And the court even acknowledged that the statute of limitations, even the statute of limitations was not pled. The Ohio Supreme Court in Mills v. White House Trucking, and this court in Matrix Acquisitions LLC v. Manley, have clearly distinguished between affirmative defenses under Rule 8C and Rule 12b6 defense. Failure to raise a time limitation that could bar recovery in the answer or through a pre-answer motion results in waiver of that defense. Once that defense is waived, Hissong's only recourse was to seek the trial court's discretionary approval to amend its answer. Secondly, the trial court did not abuse its discretion when it denied Hissong's untimely request to amend with no substantive explanation for its 2-year delay. Hissong not only gave no explanation for the delay, but it claimed, and it still claims, that the amendment is completely unnecessary. The Ohio Supreme Court in State Exrel Smith v. Adult Parole Authority and at least 5 9th District appeals decisions held where a motion for leave to amend is not timely tendered and where no reason is apparent to justify the delay, the trial court does not abuse its discretion in refusing to allow the amendment.
I want to make sure I understand in regard to the motion for summary judgment that was filed.
Yes, ma'am.
So the appellant filed the motion for summary judgment and said that you had violated the terms of the contract by not filing it within 12 months.
Yes,
Is that correct?
Yes, Your Honor.
And at that point, did you say, well, you didn't raise as an affirmative defense?
No, we did not. It's not our burden to tell them that they didn't raise it as an affirmative defense.
No, but isn't it your burden to show prejudice? And if so, if you were always defending against that 12 months, how are you prejudiced?
Your Honor, to tell you the truth, we didn't realize that they hadn't pled it until we raised it with the court. And when we raised it with the court, this court has held that a spectra of prejudice exists where a party moves to amend in response to a dispositive motion. And we believe that this is the same principle kind of in reverse.
Thank you.
Yes, Your Honor. Here, the trial court gave full consideration to defendant's motion, which is clear by her order that acknowledged that leave to amend shall be freely granted where justice requires, but emphasized, at this juncture, protracted litigation has occurred in this matter, including multiple motions for summary judgment and now Hissong's motion for judgment on the pleadings. Due to Hissong's failure to timely plead the defense of statute of limitations, Hissong's motion for leave to amend the answer is denied. Judge McCarty's order is docket number 118 for your reference. Additionally, appellate courts refrain from substituting their own judgment for that of the trial court, especially where a delayed request for leave to file an amended pleading lacks substantial justification. In the Ohio Supreme Court case of Turner v. Central Local School District, the facts were analogous, but in Turner, unlike here, the trial court granted the defendant leave to amend, and the Supreme Court, the Ohio Supreme Court, deemed this to be an abuse of discretion. The court noted that the motion to amend was filed after a trial date was set and 2 years and 10 months after the litigation had commenced. The plaintiffs were forced to expend time, resources, and money to oppose a motion for summary judgment, and this was after the experts were in place and discovery was complete. In our case, the motion for leave was filed 2 years after litigation commenced, more than a year after discovery was over. Multiple dispositive motions had been filed, and the trial was about to commence. This court has stated, again, that a specter of prejudice exists when a party seeks leave in response to a dispositive motion. This is essentially what happened here. Again, if the court agrees that the time bar defense is waived, this would moot any remaining issues. However, I will discuss assignment of error as number 1 next. The trial court did not err in allowing plaintiffs to try the implied warranty of merchantability claim, since the term limiting the statute was not in the original agreement and was not not incorporated into the original agreement. RC 1302.98 establishes a 4-year limitations period for bringing claims alleging breach of a sales contract, including breach of warranty. It further states that the parties can reduce the 4-year limitations period through the original agreement. The original agreement in this case was the purchase agreement signed by Heather Martin on September 9, 2016, which contains no provisions reducing the limitation period. Almost 3 weeks after the original agreement was signed, Hissong sent warranty agreements to Heather Martin by email and asked her to sign and return them, signifying receipt of the items, which she did the same day. Before this time, Heather had not seen, read, or received these warranties. This is set forth in the record as an affidavit of Heather Martin attached to H.B. Martin's brief in opposition to Hissong's summary judgment filed on September 9, 2021, and its docket number 72, Exhibit C for your reference. These documents contain language purporting to reduce the time for bringing a legal action arising out of the purchase or use of the truck for 1 year from the accrual of the cause of action. But because the warranty agreements were not part of the original agreement, the provision was not valid unless they were incorporated by reference, which they were not. The case of Volovitz v. Tremco Barrier Solutions lays out Ohio law regarding the doctrine of incorporation by reference. The
Will your
Ohio,
client recover though on the limited warranty?
Our-
Provision?
the implied warranty.
I'm sorry, implied, what's I meant to say?
We recovered on the
That's
implied.
the one that was signed, that's the second, that's part of the second signed document.
No, the express limited warranties were what were signed. Those, the jury determined unanimously that they failed of their essential purpose,
Okay.
which now the implied warranties were disclaimed by the express warranties. So we did not have a claim until those warranties failed of their essential purpose. At that time, as a matter of law, we had the implied warranties. The case of Volovitz v. Tremco Barrier Solutions lays out Ohio law regarding the doctrine of incorporation by reference. The original agreement must make clear reference and describe the document to be referenced in such terms that its identity may be ascertained beyond doubt. The reference must be clear and unequivocal. It must also alert the non-drafting party that the terms are being incorporated, specifically describe the document, clearly demonstrate that the parties intended to incorporate, and express the party's intent to be bound by the incorporated terms. Mere reference is not sufficient, which is what we had here. We had none of those terms that we needed. These warranty agreements were not incorporated by reference under Ohio law. In fact, there is a conspicuous absence of any argument in Hissong's briefs that these agreements were incorporated by reference into the original agreement. Hissong instead relies on the fact that plaintiff eventually received them, signed them, and sought warranty repairs. However, this argument disregards the statutory framework and misconstrues the issue. The attempt to reduce the 4-year limitation period through agreements other than the original agreement does not comport with the language of RC 1302.98. Thus, the statute of limitations was 4 years. It is undisputed that plaintiffs filed their complaint within that time frame. We would ask the court to affirm the trial court's rulings and reject appellant's assignments of error. Regarding prejudgment interest, Your Honors, RC 1343.03A supports the interpretation that it applies broadly in contract cases through the specific words where money becomes due and payable under any judgment, decree, or order for the payment of money arising out of a contract. The Ohio Supreme Court decision in Royal Electric is a governing precedent when it comes to PJI and contract cases. In Royal, plaintiff construction companies suffered significant losses as a result of the delays in 2 projects. The damages awarded for breach of contract in that case were consequential damages for loss of profits, not for sums due under the contract and not paid. The Supreme Court held in a case involving breach of contract where liability is determined and damages are awarded. The aggrieved party is entitled to prejudgment interest on the amount of damages found due. The award of prejudgment interest is compensation to the plaintiffs for the period of time between the accrual of the claim and the judgment. Accrual of the claim for breach of warranty under a sales contract occurs as a matter of law at the time of delivery. 3 of this court's cases, Decide v. Franklin, Magnum Steel Trading v. Mink, and Zach v. Sokol, held that when a party prevails on a contract claim, prejudgment interest should be awarded under RC 134303, even when there is no explicit term for payment of money. RPM, which was decided before Decide, Magnum, and Zach, does not apply because the facts are readily distinguishable from our case. In RPM, a confidentiality agreement was entered into by a manufacturing competitor in order to inspect the books in the facility of another manufacturer to evaluate the company for acquisition. The confidentiality agreement was breached, but no money was ever due under the confidentiality agreement. Here, a valid contract existed where money did change hands, and H.B. Martin purchased a truck for $139,500 from Hissong with an express warranty for services. When this warranty failed, damages accrued as a matter of law. Hissong's failure to perform resulted in the deprivation of both the use of H.B. Martin's money and a serviceable truck. This is similar to the losses in Royal. Further, services were owed to H.B. Martin in exchange for the purchase of the truck. Services due and owing to H.B. Martin that they didn't receive, as Hissong never provided a well-serviced truck to H.B. Martin. Those services, if not under warranty, would have been paid for by money. In Zech, Magnum, and Decide, this court stated that once a plaintiff prevails on a contract claim, the trial court must award the party prejudgment interest. The award is mandatory and not a matter of the court's discretion. The only matter within the court's discretion is the determination of the starting date upon which to calculate prejudgment interest, which in this case would be the accrual of the claim of breach of warranty, which was September 9th, 2016, which is the date of delivery of the truck. We would ask this court to reverse the trial court's ruling on prejudgment interest and award $81,050, which is the statutory interest rate calculated from September 9th, 2016 to October 11th, 2022, which is the date of the judgment. Is there any further questions? Thank you.
Hearing none, thank you, counsel.
Thank you.
You may proceed with your rebuttal.
One moment. Thank you, Your Honors. Again, starting with the third assignment of error about leave. There was a question about whether or not, from Your Honor, that there was any 9th District case holding that a contract term needs to be pled as an affirmative defense. The answer to that question is no. There is no Ohio case holding that either. There were a few cases cited by HBM where a court in passing mentions that a pleading cited a contract term or a time bar contract term in its pleading, but that's not the question before the court. The question before the court is not what can you plead in your answer, it's what you must plead in your answer. And so, we maintain that there was no requirement for us to plead this defense in the first place, but that again, we did seek leave to amend in an entirely non-prejudicial way, just to avoid really, half of this appeal, candidly. To that same point, I think it is important to comment on the trial court's decision about waiver of the defense, because HBM's counsel just touched on it, and we agree on the quote, certainly. The trial court said, due to Hissong's failure to timely plead the defense of the statute of limitations, Hissong's motion for leave to amend its answer is denied. Again, this goes back to one of my first remarks about contracts and statutes not being the same thing. Even the trial court's ruling on this issue is about a statute of limitations defense that was never being discussed.
The defense is called statute of limitations, it's not called
Right, statute not, yeah, exactly.
contract provision.
Exactly correct.
Counsel, I'm trying to figure out, when the trial court originally denied summary judgment to your client, it did say the contractual provision of 12 months is not applicable.
Yes, so I won't, is that your question?
No,
Okay, sorry.
I'm just getting to my
Oh,
question.
go ahead.
So my question is, why does this all matter? Because it was rejected anyway, so I'm trying to figure.
That's a great question, and one I can certainly answer. So I'll try not to get too far into the weeds on some of the procedural history here, although it's outlined in the briefs. We make the contract argument in the MSJ. The court's errant ruling on that is where it starts veering into talking about statutes and what statute might apply. It applied a separate statute, I don't remember the number, but that statute provided for a 2-year statute of limitations. So, and this is certainly agreed, within 2-3 days of that opinion, we filed a motion for judgment on the pleadings that said, whether you go 12 months or 24 months, they waited almost 4 years, so we win either way. So that was really the crux of where we went into these motions for judgment on the pleadings. We always maintained, per the first argument in MSJ, what I'm arguing to this court right here today. But when the court then started going down the statute of limitations path, there was additional opportunity to, I guess, still succeed in the case if the court was going to go that direction. And I think it's really important too, because in that motion for judgment on the pleadings briefing, the trial court has essentially already agreed with Hissong's position before this court, insofar as the trial court later commented that it was a contractual term, it was governed by 1302.98, it would typically then be a 4-year statute of limitations. Of course, that same statute says that commercial parties can whittle it down to 1 year, which we did here. And then when we got that ruling and synthesized it all together, we filed another motion for judgment on the pleadings, which is the heart of this appeal today, by the way, this last motion for judgment on the pleadings. That hadn't been ruled on until we went into trial, and the court basically didn't address it and just said that motion was filed without leave of court, and so here we are.
Well, I guess my point with my question was, I understand in regard to, your appeal in regard to judgment on pleadings, but your contested error in regard to the trial court not allowing you to amend your pleadings to allege an affirmative defense, I'm just not sure I understand what's at matter anyway, because the court considered everything that you argued. It's not like you hadn't argued it and you wanted to argue it then, and the court said, no, you can't. Whether you call it a statute or whether you call it a contract, you argued it was 12 months.
So to clarify that, Your Honor, in the MSJ ruling, the court denied the 12-month argument because it believed that a 2-year statute applied.
Right.
But the court later
I understand that.
reversed
But the
itself.
whole point is, everybody was arguing as to how long you had.
Correct, exactly.
So
right.
the issue was before the court, and the issue was briefed before the court.
Absolutely.
Okay.
Both the contractual and then once we started veering into statutes, whether it was 2-year statute or a 12-month contract term. If I
Yes,
could.
if you would please just wrap up.
Yep, yes, just very briefly.
Very brief.
Very briefly, assignment of error number 1, incorporation. That was discussed at length by HBM. Just a few quick notes on
Okay,
that.
You really are gonna have to
I'm done.
conclude.
Okay, I'm
So,
sorry.
that's okay.
All right, well, thank you for your time, I appreciate it.
Thank you. Thank you both for your presentations. The court will take the matter under advisement. I know the time can go fast when you're out there and you have a lot to share, but as I mentioned at the outset, of course, we have read your briefs. We'll take the issue under advisement, issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. And the court is now